I'm Dru Stevenson, and this is for my administrative law class. Here I'm going to be talking about one of the exemptions to the Freedom of Information Act. This is FOIA Exemption 4, which exempts from disclosure information that's basically trade secrets that the government has, or trade secrets of private corporations, or commercial and financial information. So let's dive in. The Freedom of Information Act requires federal agencies to turn over information or documents upon request, subject to 9 big exemptions or exceptions. And one of those is Exemption 4, which says that the disclosure requirements of FOIA do not apply to, quote, trade secrets and commercial or financial information obtained from a person and privileged or confidential. Exemption 4 is actually one of the most litigated FOIA exemptions. It's also very important for businesses or companies that have to interact with the federal government or federal agencies in some way. For example, there's regulatory reporting requirements where companies have to report their production of hazardous materials or waste disposal or workplace safety accidents or things like that. A lot of companies have to get various types of permits and licenses from federal agencies, and in the process, they have to submit a lot of information and data, some of which could be sensitive information for their business or things that they wouldn't want all of their business rivals to have. And the federal government gives out a lot of contracts. They hire a lot of government contractors to provide either goods or services. So the defense industry will hire companies like Boeing or Lockheed Martin to manufacture fighter jets or military equipment. Like the Food and Drug Administration may hire outside private laboratories to help with some of their food safety testing or things like that. The text of FOIA Exemption 4 seems pretty straightforward, but in practice, the courts have created a two-prong test for determining whether the information should be kept confidential or disclosed to the party that's requesting it. Both of these prongs are going to turn on whether disclosure would, number one, impair the government's ability to obtain this type of necessary information in the future. In other words, will this have a chilling effect or disincentivize parties from complying with disclosure requirements or reporting requirements in the future? And secondly, whether it would actually cause substantial competitive harm to the original submitter, whoever gave the information to the government in the first place. FOIA Exemption 4 cases can be pretty complex because the definition of trade secret under Exemption 4 is usually broader than the common law definition. This can be confusing. We do have an area of law called trade secret law that has its own body of law and statutes and court decisions and so forth. Even though FOIA Exemption 4 references trade secrets, the definition is used by the courts more broadly to apply to basically almost any commercially valuable secret information or data. And that makes it a pretty critical shield for companies who want to keep private things like their proprietary business strategies, pricing data, or a special manufacturing process that they have submitted to an agency like the Food and Drug Administration or maybe the Environmental Protection Agency. So FOIA Exemption 4 actually does more than just protect commercial interests. It actually helps the government to regulate and to hire government contractors by assuring businesses that their most sensitive data won't be weaponized by competitors through a FOIA request. Sensitive business information is often essential for regulatory compliance, contract negotiations, or license and permit applications with federal agencies. Without this type of assurance, the companies might have a perverse incentive to submit less detail or be less forthcoming with information when they deal with an agency, or to obfuscate data, or maybe to refuse to seek government contracts entirely. And all of those things could hinder effective governance by these agencies, whether that be in the form of regulatory oversight or government procurement. Even so, the exemption is not absolute. Agencies, when they get a FOIA request, are going to have to carefully review the potential harm to whoever gave the agency that information. And remember, the courts are going to have the final word in individual FOIA disputes. Courts are normally going to require either the agency that doesn't want to disclose the information that someone is requesting, or the original submitter of the information who doesn't want a third party to obtain it. One or the other of those two entities is going to have to provide a fairly detailed affidavit to the court that proves that there would be substantial harm if the information was disclosed under FOIA. So there is a burden on the agency, and or this could be passed through to the submitter of the information to show that there would be it would be harmful to disclose the information. Otherwise, there's a presumption that the information should be disclosed when there's a FOIA request. And this helps keep Exemption 4 from becoming just a blanket protection for all business data or information that is ever turned over to the federal government. We have a very recent example of litigation about Exemption 4 that went to the United States Supreme Court in 2019. This is Food Marketing Institute versus Argus Leader Media. And I have a separate video about this case I hope you'll watch. And just to give you the basic holding here to help your understanding of Exemption 4, the Supreme Court in that case held that Exemption 4 applies when owners of information, quote, customarily and actually treat it as private and provide it to the government under an assurance of privacy. And that concludes our short video about FOIA Exemption 4. Thanks for watching.